Law of evidence, presumption of facts. Principles of presumption of fact has been defined as the process of determining one fact based on the existence of another without the existence of any legal rule. It is always rebuttable and goes away when explained or rebutted. The position of presumption of fact is uncertain or transitory and are derived on basis of law of nature, prevalent customs, and human experience. Rules under Evidence Act 1950. When this act provides that a court may presume a fact, the court may either accept the fact as established and until it is refuted, or it may demand for proof of it. As a result, notwithstanding confirmation of the fundamental facts, the court may exercise its discretion in applying such a presumptions. These are the sections under Evidence Act 1950. Section 86, Section 87, Section 88, Section 90, and Section 114. Case laws and or example. The first case is Muhammad Hassan against public prosecutor. The second case is public prosecutor against Sheikh Muhammad Faisal bin Sheikh Ibrahim. Application of rule in the case of Muhammad Hassan. Under this new clause, the rule against double presumption has been effectively repealed. As a result, the presumption was not countered because the accused did not submit any rebuttal evidence. Using a double presumption, the Court of Appeals reversed the acquittal and found the accused guilty of trafficking. Application of rule in public prosecutor against Sheikh Muhammad Faisal bin Sheikh Ibrahim. Because of the flaws and improbabilities in the case, the charge cannot be upheld or even reduced to a lesser charge. The prosecution had relied on circumstantial evidence but had failed to establish a prima facie case. Hence, the court had to acquit and discharge the accused. Commentary. I believe that presumption of fact is an important part of establishing evidence since the burden of proof is directly related to the presumption. It shifts the burden of evidence on the other party to establish that the presumption is false against the party that is the beneficiary of the presumption.
Secondly, we're going to discuss on the presumption of law. What is presumption of law? Presumption of law are artificial presumptions founded on legal principles that are required and the court cannot decline to draw the presumption. There are two types of presumption of law: rebuttable and irrebuttable presumption. As mentioned, there are two types of presumption of law. The first one is rebuttable presumption of law. This can be seen in Section 4, Clause 2 of the Evidence Act 1950. Meanwhile, another one is irrebuttable presumption of law. This can be seen under the provision of Section 4, Clause 3 of the Evidence Act 1950. First, we're going to look into rebuttable presumptions under Section 4, Clause 2 of the Evidence Act. In this provision, it stated that the court shall presume that the fact is proved unless and until it is disproved. Such presumption does not provide the court with discretion. Instead, the court is bound to assume that the fact is proved. Thus, any party alleging otherwise has the burden of proving so. To understand more on the rebuttable presumption of law, we're going to look into the case law. This case law discussing about the Section 112 of the Evidence Act, which defined the presumption of legitimacy of a child. Based on the case, the Court of Appeal decided that Section 112 does not exclude an investigation into the child's paternity. However, the application for Section 112 of the Evidence Act, you can see that it is outdated and should be amended to provide the discretion for the court to rely on DNA testing or other scientific evidence to establish and disapprove the legitimacy of law. This is because Section 112 was convicted during the time where there are no clear methods of identifying a biological parenting. Next, we're going to talk about irrebuttable presumption of law under Section 4, Clause 3 of the Evidence Act. This provision indicates that the presumption of law cannot be rebutted once the law presumes it. It will become the conclusive proof of the presumed act. Moreover, it is said to be cannot be rebutted by evidence and must be taken to the case. Under Section 113 of the Evidence Act, even the prosecution cannot prosecute a kid under the age of 13 with rape, but there is no restriction to charge him with other offences. That is all from us. Thank you.
Created using Powtoon.